All rise. Within a district court is now back in session. The Honorable J. Cedric Simpson, President.
Maybe see. Court does call the case of the People versus Jules Calphone.
Good evening, Your Honor. Mr. Elvis for the people.
Your Honor, Sunitha Dadamani on behalf of Mr. Calphone.
Was there anything from either side, or did they? Well, before you begin, let me just say a couple of things. I'm not sure that people sometimes understand how courts work. I'll speak certainly for this court and this judge. The decisions that the court has to make are certainly balanced upon certain things. I've received a number of communications not coming through the parties. I've shared those with the parties. But people should understand that those don't sway me one way or another. The court's decision, while we live in a country that's democracy, so it says, my decision is not a democratic thing. I don't go on votes. While I appreciate people's opinions about things, some of which I may vehemently disagree with, the way to get that is those that may want to get things through the prosecutor's office, who feels that they're on that side of the issue. There are victims advocates and others that can get that communication to the court, and in a manner in which counsel can look at it and determine whether or not that's something that should properly come before the court, because they know. And from the defense side, same thing. While I appreciate you guys wasting the paper and the ink, those have no bearing on me. I'm going to make my call based upon what I see, what are the facts of the case. It also, I will just say, I read every one of them. And with all due respect, some of the comments, and I say this and with all the respect that I can possibly muster, things aren't factually based. The facts that some of these things are predicated on don't exist in this case, which is sort of makes a lot of it, in my mind, sort of statements of ignorance as to where they're coming from and conclusions that then come through that. So I would suggest to those that may want to write to the court or information that they work through the appropriate ways of doing that. Send it to counsel. Let counsel decide if it should come before the court, because otherwise, again, it's not going to have any bearing on me. Certainly not at this stage. I also am troubled because we are at a stage where the court is just dealing with bond consideration. And there are statements that are made have flipped everything about American jurisprudence on its head, because there's this presumption that Jules is guilty. Folks, understand something. He has not been convicted of anything. Nothing has come before the court that has rendered any decision about any bit of his conduct. And I don't know myself, in terms of the evidence that's there, whether or not that evidence is going to be sufficient that a conviction would even occur. But everybody is quick to just presume he's guilty. And maybe people should take a moment, based upon what I see in these letters, and reflect upon that. Because some of this, while they try to couch it in other terms, and I say this in a respectful way to Jules and others like him, some of the presumptions are being made that he is something because he's different. It's not how we work. That's not how this court works. That's not what we don't do things to people because they may be different, because they may conduct themselves in different ways. I am looking solely at the allegations that are in the case, the facts, and the facts of the case. I'll emphasize that word, the facts of the case as they relate to these particular charges. So I would ask that you just refrain from doing that. If you want to send it, you send it. They're going to end up the same place that everything else is and going to have the same impact on this judge. I've been doing this a while. I know what I'm doing. I get it. And I will just say as a personal note, I'm dismayed as a family of educators and being an educator and professor myself with some of the presumptions of people who presume to be or say they are educators. Because sometimes the primary job of an educator is in a room full of kids or a room full of students. You have to deal with those that are of the least and those that are of the highest. And you have to do for both of them. And some of the statements that I see from some of the teachers, it distresses me, being a product of the Ann Arbor public school system myself, that there are teachers that believe that because Jules is who Jules is, it seems they don't want to deal with children that may be like him. That is what I see. Ma'am, you can shake your head all you want. If you want to talk in my courtroom, you don't get to talk here. And you can take yourself out into the hallway. You hear me? Am I understood? So what I am going to do and what I've elected to do is to adjourn this hearing. There may be things that I may request of counsel, such as a full threat assessment. So I may be requesting that. I haven't made that final decision and determination on the bond and its conditions. I'm going to adjourn that to September. I was going to do the 3rd, but 10th, the 3rd doesn't work for council. So I'm going to adjourn this to September 10th, 2026.
Thank you, Judge. May I request that it be in the morning section of the
I
document?
want it morning.
If it's possible, I have to be back in Detroit at 5, and I'm not sure I could make it if we set it for the
If
afternoon.
it's like today, yes.
Thank you, Judge.
Ms. Valtez, you have any?
Not at all, Your Honor. That's
I'll set it at 9. Is there anything else?
No, Your Honor.
no, Your Honor.
All right, bond will continue. Thank you. Thank you, Jules.
Thanks. Bye.
Bye-bye. 14A. 14A stands adjourned.